How do you sell an inherited house? To sell an inherited house, follow this order. Confirm who has legal authority to sign, secure, and insure the property, check title, liens, mortgage, and occupancy, document the date of death value for taxes, align the heirs, decide whether to sell as-is or make targeted repairs, then list, close, and distribute proceeds through the estate, trust, or legal owners. That order matters because inherited sales fail when families list too early, discover a title problem too late, or skip the tax records they will need after closing. I am Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and, when probate or trust administration is involved, an estate or probate attorney. Here is the step-by-step process. Heirs, executors, trustees, and families should follow before selling an inherited house. Who has legal authority to sell an inherited house? You cannot close the sale of an inherited house until legal authority is documented through probate, trust administration, joint ownership, a transfer on death deed, or another valid transfer path. The person with authority may be an executor, administrator, personal representative, successor trustee, or surviving co-owner. The right answer depends on how title was held and what the will, trust, deed, or court order says. Can an executor sell an inherited house during probate? In many states, an appointed executor or administrator can market the house during probate, but the sale cannot close until probate requirements, title requirements, and any required court approval are satisfied. If probate applies, the key documents are letters testamentary when there is a will, or letters of administration when there is no will. Those letters show the title company, broker, and buyer who can sign listing agreements, contracts, deeds, and closing papers. Before you list, gather the death certificate, deed, will, trust documents, court papers, and any authority documents connected to the estate. How do you secure an inherited house before selling? Secure and insure the inherited house before you market it, because the estate is still responsible for damage, theft, vacancy issues, utilities, and basic property condition. The first step after inheriting a house is not choosing a listing price. The first step is protecting the asset while legal authority and ownership are being confirmed. Change or confirm the locks, reset alarm codes and smart home access, keep necessary utilities on, manage climate control or winterization, forward mail, maintain the yard, and remove obvious vacancy signals. Insurance is a major risk point. Contact the insurance company quickly to confirm the policy is in the correct name, such as the estate or trust, and to confirm whether vacancy coverage is needed. A normal homeowner policy may not protect a vacant inherited house the way heirs assume. Also, secure valuables, documents, firearms, jewelry, and personal property before contractors, buyers, inspectors, or family members start moving through the house. What title, debt, and occupancy issues should you check before listing? Before listing an inherited house, open a preliminary title review and check liens, mortgage payoff, property taxes, HOA issues, and occupancy so the sale does not collapse in escrow. A title company or attorney should confirm how title is held, whether there are recorded liens, whether an old mortgage was never released, whether the property is in a trust, and whether probate documents are needed before closing. Can you sell an inherited house with a mortgage? Yes, if the mortgage, HELOC, reverse mortgage, taxes, HOA dues, and other liens can be paid off or resolved at or before closing. If there is a reverse mortgage, contact the servicer immediately because deadlines can move quickly after the borrower dies. Occupancy matters too. A vacant house, a tenant-occupied house, and a house occupied by a family member each require a different plan. If a tenant is involved, state landlord-tenant law controls notices, lease obligations, and move-out options. This is where a clean title and lien check saves the family from spending money on repairs or marketing before knowing whether the house can actually close. Why do you need a date of death appraisal before selling? Before selling an inherited house, document the date of death fair market value because that value generally becomes the home's federal income tax basis. Do you pay capital gains tax when you sell an inherited house? The tax is generally on the gain above basis, not on the entire sale price, which is why the date of death appraisal is one of the most important records in the file. For example, if the inherited house was worth $475,000 on the date of death and later sold for $510,000, the potential gain starts around $35,000 before adjustments, selling costs, improvements, and each heir's own tax situation. If a federal estate tax return is filed, or if the estate uses an alternate valuation date, or sends beneficiaries a Schedule A to Form 8971, the CPA should coordinate the basis numbers so the sale reporting matches the estate records, keep the appraisal, closing statement, improvement receipts, and any CPA notes with the estate records. Those documents are what protect the family if a tax question comes up later. Should you sell an inherited house as is or make repairs first? Sell an inherited house as is when speed, distance, cash constraints, or major deferred maintenance matter more than maximizing retail price. Make targeted repairs when they clearly increase the buyer pool or net proceeds. The best repair plan is practical, not perfect. Most inherited houses do not need a full renovation before sale. They need enough cleaning, safety work, and presentation to attract the right buyer for the condition of the property. Should you repair an inherited house before selling? Repairs are worth doing when they improve safety, financing, or first impressions more than they cost in time, stress, and cash. Roof HVAC, electrical, plumbing, mold, stairs, and other lender-sensitive issues can affect whether normal buyers can get a loan. Capital improvements may increase tax basis, while routine repairs and maintenance usually do not. Keep invoices and receipts, and ask the CPA which expenses matter for tax reporting. The decision should come from the current market analysis, the home's condition, the family's timeline, and the broker's honest estimate of what will actually pay for itself. What if multiple heirs disagree about selling? If multiple legal owners inherit the house, they generally need agreement to sell unless an executor or trustee has sale authority, a buyout is arranged, probate court authorizes the sale, or a partition action applies. What happens if a sibling refuses to sell an inherited house? The practical path is usually a buyout, mediation, a written sale agreement, or instructions from the probate court before anyone considers a partition action. A partition action is a court process that can force a sale when co-owners cannot agree, but it is usually expensive, slow, and emotionally damaging. Treat it as a last resort, not the first plan. Before the listing goes live, agree on the expected price range, repairs, who pays expenses, who talks to the broker, and how proceeds will be distributed. Use a shared ledger for mortgage payments, insurance, taxes, utilities, repairs, cleanout costs, and reimbursements. Inherited sales are emotional because the house is also part of the family story. Clear authority, written decisions, and one designated point person help keep the transaction from falling apart. Who should you hire to sell and price an inherited house? You should hire a broker who understands inherited property sales, probate timelines, trust sales, title company requirements, disclosures, personal property, and out-of-state heirs. A standard listing agent may know how to sell a clean owner-occupied home, but inherited houses often come with court documents, estate attorneys, CPAs, vacant property risks, family disagreements, repairs, and title problems. How should you price an inherited house for sale? Price it from a current market analysis, not just from the date of death appraisal. The appraisal helps with tax basis. The listing price should reflect today's buyer pool, condition, comparable sales, carrying costs, and whether the house is being sold as is. A good inherited property broker can coordinate with the attorney and CPA, communicate clearly with multiple heirs, manage a remote process for out-of-state family members, and explain which repairs, cleanout steps, or disclosures matter before showings begin. The goal is not just to get the highest headline price. The goal is the best net result with fewer delays, fewer title surprises, and less family conflict. What happens at closing and after the sale? Closing happens once legal authority, title, buyer requirements, lender requirements, and any court requirements are satisfied. At closing, the deed may be signed by an executor, administrator, personal representative, trustee, or legal owner in the correct capacity. The title company may ask for the death certificate, letters testamentary, letters of administration, will, trust, court order, deed, payoff statements, lien releases, and tax information. Where do inherited house sale proceeds go? If the estate or trust is the seller, proceeds often go into an estate or trust account first, then get distributed according to the will, trust, court order, or ownership structure after debts, expenses, and tax obligations are handled. What is the safest way to sell an inherited house? The safest way to sell an inherited house is to work in order: legal authority first, property protection second, title and debt review third, tax basis documentation fourth, heir alignment fifth, and then listing, closing, and distribution with the right professionals. That sequence protects the estate from delays, uninsured loss, title defects, tax mistakes, and family conflict. It also gives the broker, attorney, CPA, and title company the documents they need before the sale becomes urgent. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free. You do not have to figure it out alone. The goal is to sell the house the right way, with the right people, and with the estate protected from the first step through final distribution.